Okay. Thank you very much. We're now on item 4, adoption of the agenda. Is there a motion to adopt the agenda? Moved by Brandon. Second by Kathy. Any discussion? Hearing no discussion, all in favor of the motion to adopt the agenda, say aye. Aye. All opposed, motion's carried unanimously. We're on public comments for non-agenda items. Anybody here have any non-agenda item comments? Anybody raising their hands? Nope. No public comments. We're now on the consent agenda, financial report, month ending March 2025, payment of bills through April 10th, 2025, minutes of March 26th, 2025 board meeting. That's items A through B. Peter, anything you want to?
There's not anything that special attention, but we're happy to answer any questions.
Great. Any questions regarding the consent agenda? Seeing no questions, is there a motion to approve the consent agenda items A, B, and C?
So moved.
Motion made by Brandon, second by Carolina. Any discussion? Hearing no discussion, all in favor of the motion say aye. Aye. All opposed, motion's carried unanimously. We're on the advisory committee report, and Dennis.
Good morning. Dennis Lamro with the advisory committee. Memo speaks for itself. I think you can see that there were two main topics of discussion. One is the revision to the rules and regs for new producers who do not report. There's quite a discussion about that. And then the other discussion was about the storage agreement, or the draft storage agreement to convert carryover to storage. Additionally, I left out one factor on item 13A, the first new production application. One of the reasons that the committee narrowly voted that down was a discrepancy between a covenant which said farming and raising animals, and then the application which said domestic. That covenant is on page 70 of the packet.
Very good.
Thank you.
And we'll address that when we get to that item. And on page 70, you said?
Right.
Great. Thank you very much, Dennis. Any questions of Dennis before he leaves us? Okay. Any discussion on the advisory committee report? Very good. Now we're on item 8, presentation 2025 first quarter year-to-date budget review, and that's going to be Peter or Angel or someone.
Actually, we're going to
Teresa. I'm sorry.
That's okay. Pete can do it.
Go ahead, Teresa.
Okay.
Good to have you here.
Thank you. Thank you. Good morning, board members. So this is the budget report for the first quarter. And there's a staff report on page 34 of your board packet. The budget versus actual report is on page 35, and the cash flow report is on page 36. And so this morning we'll take a look at the budget report and then touch on some of the highlights. And so this is the budget report on your screen. The first column is the actual 2025 budget numbers. The second column is the 2025 year-to-date actual numbers. So these are the revenues billed and the expenses incurred through March 31st. And then the third column is the percentage of actual to the budget. So if the revenues and expenses were spread evenly over the year, we would expect to see 25%. Okay, so looking at the report, total revenues budgeted were $1.036 million, and total year-to-date billed revenues are about $755,000. And of that number, about 97% has been received, so that's really good. And total expenses, $980,000 budgeted. Actual year-to-date, about $170,000. So 17% of budgeted expenses incurred through March 31st.
Do you have any explanation on those numbers?
Is there a specific number, Rob?
Well,
What?
so our budget, if I'm looking at this right, of expenses is $979,810 for the year, correct?
Right, so that was the budgeted amount.
And so far, our expenses are $175,30,
Correct.
and that's 17%. Do you have an explanation that, and if going by what you said before, we should be looking at around a 25%?
Right, we would expect to be about 25%. It varies just because of, obviously the administration is lower than we budgeted for a new administrator. So with AVEX still doing that, the administrative services are at 10%. Legal services are pretty close. Watermaster engineer is 15%. There's a couple of smaller ones that are a little high. The audit is high at 87%, but they're almost done. So there won't be costs further on in the year. That'll be 100% through the year.
So specifically, my question then is for the administrator and our Watermaster engineer, have all of their billings through the first quarter been made, or are there any being held?
This includes all of the billing through the first quarter.
Okay, very
I
good.
had another question.
Yes.
So I was actually interested in the revenue, and I was just surprised to see that so much of the anticipated revenue has been realized. So I guess my question is that just when it comes in, we typically would see it in the first quarter, or are we anticipating greater revenue than was what we were budgeting?
So the fixed administrative assessments, that's the $682,000 that was billed. That's all that's going to be billed for that. There's only the imported water return flows and the variable assessments that haven't been invoiced yet. So the revenues actually will be higher. But the 97% is what has been collected of what's been billed so far. Does that answer your question?
Yeah, so if I were to paraphrase, what I'm hearing is that we might have a larger revenue than anticipated, but not significantly higher, that perhaps that we've just realized the bulk of our revenue, and it's just the way it works out in the first quarter.
Yes,
we
realized the bulk of it, yes.
Very good. Okay, thank you. And go on, I think I interrupted you.
That was all I was going to point out, but again, we'll take a look at this again after the second quarter in July and make sure we're still on track.
So I did have like the question, I see down here, the general and cyber liability insurance is at 117% of the budget. So that was probably more than we expected.
Right, we budgeted $5,577 and the invoice was actually for $6,500. So when we did the budget, it was an estimate. So it was higher than what we estimated.
Thank you.
Okay, anything else?
That's all I have.
It's looking great, Teresa. Thank you.
Good, thank you.
And no other questions from the board? Okay, takes us to item 9, consideration possible action concerning selection of the Watermaster administrator, and I think our attorney's going to talk to us about
This
that. Craig?
was a request that we talk about what the options are going forward with respect to the administrator. We're operating currently under the MOU from 2024. Last session, there was an amendment proposed to the MOU that did not get unanimous consent, but it is an option to go back to the First Amendment of the MOU if the board wishes to do so. The third option is to go for an RFP, RFQ. The board may want to start that process as soon as possible, but that's a third option for the selection of administrator. And fourth, if there's no consensus and the board wants direction from the court, we have the authority to go in and ask the judge to resolve any final dispute that there might be on the issue of the administrator's selection. So those are the 4 options that I see. It was a matter for simply discussion. If the board wants to direct action on it, we're certainly
Okay.
willing to do so.
Thank you, Craig. I'll start this discussion. We had a good discussion last time. I think that, again, we've worked real hard to get consensus for almost 9 years now. And this came up at AVAC. Obviously, I get direction from the AVAC board on how to proceed. And about the discussion last week or last month, we had Derek and Angelica requesting for an RFP. I think we had some votes, and so maybe to cut this short and get some discussion, AVAC would be fine with putting out for an RFP and going through the process again if that's what the board's desire is. I think that should help us move towards consensus and build consensus on how we handle this. And that's just what I would recommend, but would certainly like further discussion from you all.
Director, I just want to be clear. AVIC is open to proposing if there were to be a new RFP.
That's my understanding,
Great. Okay. Thank you.
but we'd have to start with the RFP first.
Of course.
Obviously, it's a board decision to
Understood.
discuss it, but, and no promises to that. It's going to take, and we're in the process of getting a new board member, but I think that would be my recommendation to our board that, we propose this if an RFP is put out. So.
I do have a question for Craig, I guess. Craig, I know we're supposed to do an RFP, but couldn't we also just request a proposal from AVAC for a professional services contract and bring that before the board to vote on that? So is there that option as well, where you don't have to go through the expense of an RFP, but rather have a document proposal from AVAC for services?
I think that could be accomplished. I'm more comfortable with the RFP, RFQ public nature of it. But if you wanted to proceed that way with the proposal from AVAC, we can make it happen.
I'm just making sure I understand.
And so to that end, I'm sorry, Brandon.
Oh, no,
So to that end, could you repeat one more time? I know what 3 and 4 were, but can you go over the 1 and 2 options?
Yeah, 1 and 2 is staying with the status quo. The current MOU from 2024 is the operative agreement that we're operating under.
Okay.
Number 2 would be to go back and vote again on the First Amendment to the MOU.
Okay. First Amendment.
Which you
Okay.
did last month. The third option is RFP, RFQ, and fourth option is going to the court.
Thank you for reiterating.
Derek, go ahead.
Well, first of all, I want to thank the chair for, trying to find consensus on this, and I hope we do find consensus today. And I appreciate representation of the AVEC board of going through that RFP process. I know, a number of the constituents I represent would be very supportive of that, as it's been made public by myself. So I would support that 100%.
if anybody can answer this, I'm curious on this. Obviously, if it did go to court, to the judge, there would be legal expense with that.
Right.
What's it look like, dollars and cents wise, the legal expense of the the expense of doing it?
First of all, you'd have to be unanimous on wanting me to bring the motion.
I'm just trying to
If you weren't unanimous on that, it would be up to some other party's counsel to bring the matter before Judge Comar.
Yeah, I think sorry to interrupt. I think we smell something burning.
Yeah, it smells like an electric bulb.
Do we need to unplug anything, or?
You'll be the first to know.
Okay,
Uh,
thank you. Do we have somebody taking a look at it, Hope?
Yes, just.
Okay. If you want us to leave, Matt, let us know. Okay,
Just said he heard some drilling, so there's maybe some construction.
we'll report back. We have a clear way forward, so I don't think we need to do anything at this point. Okay, any more discussion on this item? The only, Peter, if you walk us through the RFQ process, and are you comfortable as the administrator doing that process if AVAC may put in a proposal, and how can we ensure that there's no issues with that process and make sure the board is on
board.
Make sure the board's on board.
There's a couple points where we might feel a little uncomfortable. We had previously met with people the firms that submitted to answer their questions about the process. It's a little awkward if we're also competing in that process. Also maybe awkward if we're receiving all the proposals and have access to those, and we're submitting a proposal. So it may be worth having a third point of contact, whether that be Craig or Dennis's chair. I know Dennis appreciates me volunteering him, versus that all of the proposals funneling back to admin staff. I do believe that admin staff could conduct themselves in a fair way if we need to run the process, but that could be a point of contention if we're running it and also competing.
Yeah, that would be my concern too. And obviously, we've always looked at, are there perceived conflicts? And AVAC has, I think, gone to great lengths to make sure there are no real conflicts or perceived conflicts. And I'm wondering, Dennis, would you come up and talk to us about what maybe Palmdale Water District would be willing to do, or if there's another solution to this, let me know. But maybe I don't think there's any issue with us putting out the RFQ and doing that process. But maybe have, and it's just because Dennis is here, either
Lucky me.
either have Palmdale Water District, we contract with Palmdale Water District, and obviously you'd need to be reimbursed for this, to actually run the process of getting the proposals, talking to who proposes, and then setting up the meetings for them with that.
I think we would be comfortable with that, but we have to look at Dennis.
And I know we're putting you on the spot. This is just all coming up right now, but what are your thoughts? And would the board be okay if Palmdale Water District did that, or would someone else be better? Or
Dennis and I go back, so this is nothing personal on this.
Yeah.
My thought is, instead of maybe putting the burden on Dennis and Palmdale, is we have two other policy, or not policy, but we have council and we have water engineer, and they could be a facilitator of this. And I look to Todd. I mean, Todd has and I don't know their scope, but I know they do, I think, some administration and some work.
good point.
In that, and I think that would be, it's all someone that's gone through the RFP process that we've all approved and can handle that, and so I maybe would look to Todd or to Craig.
Yeah,
As it may not be the Todd Watermasters that we deal with, but somebody else.
you may be off the hook, Dennis. Let's explore that.
Thank you, Derek.
Let's see. So, Craig, actually, I should have gone to you first. What are your thoughts? How should we propose?
Well, I have no problem doing it. I have an independent duty to the board, so technically, legally, I think I'm clear to do that work. I don't see an impediment to it unless somebody brings something to my attention. I can see administrating that process with Arden, if that's what the board is wanting to
You
do.
said with Arden?
With Arden,
Yeah, I'm thinking, always looking at our budget.
yeah.
So it would be, I mean, you could oversee it with Arden or Todd Engineering
Right.
conducting it. How would that be?
To direct the process,
Yeah.
the hearings, the information with Arden, I think it's doable.
Okay, and Arden, your thoughts about that?
Yeah, it is doable. One question I have is, would this be within our existing budget or additional scope of work?
Well, I would think it would be an additional scope of work because our administration would have to do it. So I would think, board, your thoughts? Yeah, exactly. Yeah, Arden, I think definitely would be, we would supplement your budget for this and I would imagine Peter can work with you on what we're looking at to supplement it. And our administration, Peter and our group will do as much of that process as we can to get it started and work with you on handing off anything that could be perceived as a conflict to you with Craig's oversight. How would that be, everybody?
Sure.
Everybody good? Dennis, you're off the hook. Do we need any type of vote at this point for that or just consensus, Craig?
I think we first need to know if we want to go the RFP process.
Okay, and that should be a vote.
That should be a vote.
Okay,
You looking for a motion?
is there a motion that we do an RFP process and maybe include in the motion that we would have would this be okay, Craig? Have our
Yeah.
attorney and Watermaster engineer, Peter and his group will start the process with sending everything out and then work with Arden and Craig to take over the administration of that part of the process. And there would be a supplement to the engineer's budget for that purpose. Did you get all that, whoever's taking the motion? Is that too much to put into it or
No, I think it's useful to have it, or break it into two, but
two?
if it can be in one, an approval of the RFP and then the process.
Yeah, let's do
Getting
the
the
approval of the
RFP.
RFP first. That's good.
I will say, I don't think it has to be purely specific of what AVEC's doing, what legal's doing, what Todd is doing. I have full trust that they know how to, administer those processes and make sure they're transparent.
Why don't we just do this, that if we agree on the RFP, put in that our attorney will administer the process through the administrator and Watermaster engineer.
And so I will make that motion that,
Okay.
that we, go the RFP process with our attorney working with the current administrator as well as with the Watermaster engineer to administer that process.
Great. Is there a second to that motion?
I'll second.
Carolina seconds the motion. Any discussion on that motion? Seeing no discussion, any public discussion? Julie?
Well, I can't say that I'm anything less than furious that we're taking these steps backwards. On any given month and any given week, we probably have 12 to 14 calls at our office with different landowners or Exhibit 4 party holders. They are 100% behind signing an MOU with AVEC and continuing on. We are in our 9th year with AVEC. Not one time have we had a conflict of interest. No issues. No issues. In using the word transparent that got thrown around last meeting by the two landowner representatives, of which I'm not feeling represented at all. And the 12 people that we speak to do not feel represented either. What looks transparent to us is we're looking to blow this up into a large, bloated public entity of which we are not. There are a few of us that are paying these bills ourselves, and it hurts every time we have to write that check. You take a 50% cut in your business, and then you get to pay $9.50 an acre foot. And like I say, I'm not the only one that's upset about this. When people call our office that are Exhibit 4 and Exhibit 3, they know that they are talking to somebody who's going to go to the advisory level, because that's where it's supposed to start, and we bring it to you. So we've got a whole lot of people that are very upset about this. We have spent so much time and money on this, and never to have ABEC be in question. This is just wrong.
And Julie, I'll just comment on it. My job as chair is to get consensus, and the rules require a 5-0 vote. You know my feeling about that, but I'm only one.
I know.
And so in order to find consensus, this proposal was the only way I could see that we could get consensus going forward, and then deal with how it comes out. And we have to listen to all of our members, right? And so if there were some other way to keep this process, and I don't think it'll be a terribly expensive process, but to do it, I think we would have searched for it. But I think we're going to have consensus on this. That's a step forward, and get through this process and work together to do it. And the other thing I'll say to you is, even though I agree with almost everything you said there, this board is stronger and better because we have worked for consensus for the 9 years, and we have to listen to each one of our members, and we have been incredibly successful working it out. So that's my response to you.
And at the advisory level, first of all, this last week, we weren't even given this topic to discuss. Just said not applicable, which isn't right either. But the month before, when we took our vote, we had a 10-2 vote at the advisory level, and the 2 were not no's. They were abstaining. Not the same as a no.
Understood. And you've been in the middle of most of these discussions. So I as one member and the chair, my responsibility is to find consensus, and that's what we're doing.
Agreed.
Sure, go ahead, Derek.
Great. Well, I would say, number one, I've met with you personally. I met with your husband last week personally. He knows exactly where I stand. I work for a family that pays the same bill that you pay and the 12 other people you talk to. I've asked you that they're more than happy to reach out to me at any point in time. You do not, or your husband do not need to be the conduit. I think this process is not to blow it up. It is to make it transparent. I will say that again. You and I may disagree. You and your husband, the other 12 may disagree, but that's truly I'm an elected position. I'm not on the advisory board. I'm not appointed by a person. I'm appointed by every landowner in this valley that owns land and pays the bills that you referenced to. So it's, small, large, corporate, as you call it, out of town, in town, we're all the same. And we may disagree about this, Julie, but it isn't personal. It's just a position where I look at it as a representative of the entire Exhibit 4.
It feels pretty personal. That I'm just going to say that. And it's not just to me. Like we say, the people that reach out to us, they're longtime residents here that know us, and they know we're going to speak for them. That's their point. They don't feel like they have any connection with you whatsoever. I mean, they do. I know a couple of guys that have reached out to you, and they didn't get calls back from what they've told me. Now,
That's not true. On the record, that is not true.
I'm just telling you what I hear.
I know, and I've heard you in the ABAC meeting a month ago make a statement about me personally. So I would just encourage you hey, I have been very transparent. I work on to try to find a common ground. This is, I think, from a landowner standpoint, the only area that we've ever disagreed on of how the process. Well, really?
Yes, it's a
Okay,
big one.
as
It's a
chair,
big one.
I'm gonna take this back over. Public comment's been made, response has been made. Any other discussion or response? And, okay, we have a
This
motion.
is Galen. Hey, can I speak?
Oh, hi, Galen. Yes, of course.
You know,
Go ahead, sir.
since Derek brought it up about our meeting, I would point out that I mentioned to him that AVEC has done the job for 8 years with no complaints. They're starting on their 9th year. If I had an employee that had worked for me like that with no complaints, and to replace him, I was gonna pay 2.5 times more money. Is that a tough decision? Not at all. Whenever we put Mr. Parton to work, who is an honorable, ethical man, it costs us money. We're wasting time and we're wasting money. Thanks. I would urge a no vote on this. Thank you.
May I comment?
Thank,
Chair, can I comment back?
thank you, Galen. Yes,
Just my-
go ahead.
so-
Derek.
So in that meeting, I agreed to disagree with Galen. I said this is a public board. Although we are appointed by the court, we act as under the Brown Act and we go through a process of every other part of our management. Legal, we went through an RFP process. We went through an RFP process on our engineer. All I'm asking is we do the same thing.
Very good. Any other comment?
One more.
Galen,
When I
wait,
mentioned,
wait,
when
wait, Galen, I'm sorry.
I just,
Go ahead.
I just wanted to respond to Derek. When I mentioned that to
Oh.
him, I did not get an answer back. I mean, there is no answer to that.
Right
When you
there.
have,
Okay, wait, I'm the chair. I'm controlling this meeting. We do it appropriately. So one at a time. Galen, go ahead and finish your comment. And then if Derek wants a response, he will respond, okay?
Derek, when we had that conversation and I told you didn't respond to that, there is no response. You don't fire somebody or make it more difficult for somebody that's doing a good job and act like you're trying to replace them. You just want to keep them going. It makes no sense to do that. You wouldn't do that in the private sector or the public sector.
Okay, Galen, are you done? I'm going to have Derek respond and I think we will move on after that.
I respond to what I already said to him. There's nothing there. It wasn't the answer he wanted, but it was what I responded.
Perfect. Okay. Thank you, everybody. Good discussion. Any other discussion from board members?
I would just like to know if we have, the estimated cost. I know it's tough to say because it just came up, but we have it accessible on what it was cost-wise last time we did an RFP.
No, I apologize.
And I didn't,
Yeah.
it's the subject that just came up, so I'm trying to figure out, the dollars, cents of it if we can.
And again, let me kind of finish where I began. My job is to find consensus, and I think this is working towards a consensus. The choices we have are to continue under the MOU, and we are not going to get 5 votes for that. The second choice is to take it to the court. I think that's always the last resort for us. We've never had to do that before, and that would be a lot more expensive than this process. So the only route I can see from listening to everybody, and as chair, that's an important part of my job, to get consensus, is to do the RFP. I don't always have to agree with recommendations that I'm making, but I am going to work real hard to get consensus, get this done. And Patty has a comment. Go ahead.
No, we have another comment on the phone.
Oh, thank you very much. Okay, another phone comment, please.
Yeah, hi, this is Jeff Siebert.
Hi,
I was
Jeff.
under the impression we've already done RFP and RFQ. Is that incorrect?
No, it is correct. We did an RFP and an RFQ, but AVEC did not put in for the last one. And I think that's Derek's concern, or some of the landowners' concerns, and that he feels to be transparent, we need to do it again, and if AVAC wants to apply, and go through the process, that's what Derek and Helika, the last meeting, were asking for. So that's the reason, I believe. Derek, did I say that right?
Correct, and as well as I'm not gonna put words in Craig's mouth, but I think Craig from council advised us that would be the best path forward too.
Okay. So Jeff, did that answer your question, sir?
I do want to note also
I
that
did.
not meet
And I
consensus.
also have a,
Wait,
hello?
Jeff, hold on for 1 second. Carolina, go ahead.
I think it's important to know that this board did not meet consensus on the last RFP.
Correct.
So that is ultimately the reasoning
Yeah.
behind why we did not make a selection. We were not unanimous as a board regarding the last RFP.
Yeah, Jeff, and very good point, Carolina, and for transparency's sake, we did the last RFP. We had candidates, we interviewed, and then I can't talk about closed session, but Carolina is correct. We never could get a consensus, and that's why AVAC continued, because the board voted before that AVAC would be the administrator while we were going through the RFP, RFQ process. So we did get consensus that AVAC would continue until we could resolve that issue. Now we're trying to resolve it. That's where we're at. Jeff, did that answer your question?
Yes, it did. Thank you. And
Great,
also, may I speak to Derek?
Well, no, you speak to the board and you speak to the chair, and I'm not going to entertain a discussion back and forth. I know Derek is accessible by his cell phone if you want to have a private conversation with him, but if it's
I'll take it. Thank you.
Okay, great. Thanks, Jeff.
Bye.
Any other discussion? Anybody else? Okay.
I just want to say one thing.
Go ahead, Kathy.
In the sense that I feel that some of the reason why this is going this way is because of a procedural thing of not doing this. So if we do this, that is the procedural thing. My only concern, and I think what the concern is of the advisory board when they say blow it up, is if we only get AVAC or we only get someone else, are we going to be willing, because now we've done that procedural thing, not to blow it up and go with AVAC now that we've done the procedural thing?
Kathy, I think that's premature. I think we do one step at a time.
Right,
And
but I'm just,
I think we just get
Yeah.
into, I think that,
yeah, I'm just saying it so that they hear that I'm listening to what they say, and for someone to say, like, blow it up, what do you mean blow it up? I think that's the underlying thing that people are concerned about.
No.
But regardless, we're not going to get consensus unless we do this. So that is why I will vote for the consensus of it all, knowing that other history and everything, but
Yeah.
not to speak about it. I don't think it does them any good, because then I don't feel that they were heard.
that you feel they
Right.
knew you heard that. Okay. No, I appreciate that. And again, we've done this for 9 years. We haven't always agreed at the beginning of things, but we have always reached consensus. So this is a process to do that. That's what's required when it requires a 5-0 vote. Sometimes it's cumbersome, but in my mind, from being the chair for the entire period of time, it's well worth doing whatever's necessary to reach consensus. So, okay, anybody else online? Okay,
I have one quick comment. Just the thing that I struggle with is, from the sounds of it, it's gonna, the cost for the legal issue to go take it before the judge is gonna be greater than RFP.
I would think
So.
No question about that.
I'm trying to be cognizant of dollars and cents of the best issue.
Right, otherwise we could bring it to the judge and let them decide that, but in looking at it, that was in my consideration too, of cost.
I think we have all been concerned about cost for the most part. Patty, Holly, anybody else? Hearing no other discussion. Patty,
We're all
Yeah.
done.
can you kind of go over what our motion is?
So I have that, the motion is to go out for RFQ, RFP for administrative services, and that general counsel will work with current administrator and engineer to administer the process.
Perfect. Okay, everybody knows the motion, and that motion has been seconded, correct? All in favor of the motion, say aye.
Aye.
Aye. All opposed? Motion's carried unanimously. And that brings us to item 10, I believe.
Right.
And that's discussion of General Counsel's March 26, 2025 memorandum concerning closed sessions. Craig, go
Right.
ahead.
The board had a memo in front of it last month concerning closed sessions and potential interest of individual board members having their counsel present. My opinion hasn't changed from the memo. As I note in there, I believe we need to be consistent with the Brown Act. According to the judgment, it's very specific on that. The meetings are to be conducted consistent with the Brown Act. I'm concerned about what happens when we open the door to one counsel. Do we have multiple counsel present? The legal standard is the person has to be essential to the closed session, not just satisfying potential interest in getting information directly. And that I don't see in the discussion on this. I think it potentially discourages communication, honest communication in closed session. So my opinion remains the same. I know the landowners, at least one council, has been in touch with me about their concerns about having multiple individual counsel available in closed session. So there may be some public comment on that. And Mr. Lemieux spoke last time, raised the issues. So this is a discussion item. There's no action to be taken unless the board wishes to go in the direction of opening up the closed session to individual counsel. There are waiver issues that I'm concerned about of the privilege and just what perception we're going to have, whether we're going to have legitimate closed sessions anymore, if that's the case. So that's my comments, haven't changed from last month, but happy to entertain questions or have further comment from the public.
Okay, comments? Board?
I'll reserve my comments till after I
Okay.
hear from the public.
Any public comments?
Hi, can you hear me?
Yes, what is your name, please?
Hi, this is Laura Jacobson, County Counsel. I advise Waterworks District 40 on the board, Carolina. And I wanted to thank Craig for, reviewing the issue. I think the comments that Keith made last time were still in play, in our opinion. Obviously, our office has a lot of experience with the Brown Act, and we agree with the conclusions of the memo regarding its analysis of the Brown Act, but disagree nevertheless with its ultimate conclusion because it's missing the larger context of the purpose of the Watermaster, which is to effectuate a legal settlement and judgment to protect the basin. And Waterworks District 40, in our opinion, should be able to discuss all agenda items with its counsel and team of engineering experts, its staff, etc., which it historically has, and it's been a great benefit to our service to the Watermaster and the basin overall. So we think this cooperative approach is directly contemplated and blessed by the judgment. You know, the public water supplier group meets in anticipation of these meetings to advise the public water supplier representative seats on the various matters, all of them, in front of the board, and strict adherence to the Brown Act in the fashion identified in the memo would frustrate that cooperative arrangement. We feel it's important that our members are adequately prepared and advised on all matters in front of the board. So we'll continue to engage council on this issue as we disagree.
Thank you. Any other comments? Oh,
This is Stan Powell, representing City of Los Angeles.
yes, go ahead, Stan.
At the advisory committee, we only had Craig's prior memo to review. We did not know where Craig stood, so I don't think we voted on it. I guess I want to support the approach that Craig has suggested. And a lot of my thinking is this entity is to implement the court's judgment. And a critical factor in this is, I think, the principle of due process. All the matters being discussed at the Watermaster may end up before the court. And I think to the extent that some parties have access to information from closed sessions and others don't, could raise some due process issues that could be problematic. So that's the input. Thank you.
Thank you, Stan. And Tom, you want to come up? Good to see you back. It's been a long time.
Thank you. Good to be back. President Paris, members of the board, I'm Tom Bunn. I'm an attorney for Palmdale Water District. And I wanted to give a little bit different approach to that. I'll say first, I did not know until I heard Mr. Parton today say this was about having council be present in a session. I took it from his memo that it was about disclosing what happens in the closed session to council, and my position is different based on those two things. I fully agree that council should not be present in the sessions. However, building on what was just said, I don't think there's any disagreement that the Brown Act prohibits disclosure of closed session matters without the consent of the board, and I'm going to come back to that in a minute. And the question was correctly phrased, is whether we should strictly abide by what the Brown Act provisions are. And to my mind, there are some things that would suggest that it might not be a good idea to have, or it might be a good idea to have closed sessions items be shared in some situations. What was referred to as not strict compliance with the Brown Act, based just on what the whole purpose of the organization is. But I don't see anything in that if nothing at all were said about the Brown Act, I think that point could be made. But our judgment says specifically in two places that we're bound by the Brown Act. There's no ambiguity in that. And I don't think that implications should change that point. Having said that, let me come back to my prior point that you can make an exception and allow your members to talk with their counsel. And you can do that either as a general rule or for particular matters. And I think that for this Watermaster, it might be appropriate in certain matters to do that. In other words, I feel that some matters should not be discussed outside of the closed session room. In other words, that you shouldn't tell people what happened in closed session, even if it is your lawyer. For example, we recently had the Zamersla case, and that was a situation where the board met in closed session to determine how to do that. I don't see any point in having board members go back and talk with their own attorneys about what was just talked about in something like that. As a matter of fact, in that situation, Palmdale Water District filed its own brief with others supporting the position of the Watermaster, and we did not need to hear what happened in closed session in order to formulate our own position. So, but there may be other matters that are heard in closed session where it makes sense to authorize your members to speak with counsel. And I just wanted to make sure that that was understood, that you can do that. There are privileged questions that I think Mr. Powell brought up, but you can have a joint defense agreement. I mean, we talk with your counsel all the time about matters like that.
Thank you, Tom. And we have had almost committees of attorneys working together with our counsel on things. And I think it's of interest what you said. And we can, if the board wants, we can explore that more, that if we have an item come up that one of our members say, it's important for me to talk to my counsel about it. And I'll just ask for this, it's an interesting point. Can we, as a board in closed session, agree on that specific item could be discussed? Is that what you're saying?
Yes.
Yeah.
I think you can.
Okay.
I have concerns about opening that door and being specific what the criteria are that allow that potential violation of the Brown Act.
But that
That's
is
not a Brown.
I understand.
wait, Tom, you
I'm
direct
sorry.
to the board.
Yes, sir.
I talked to our attorney. Go ahead, Tom.
Thank you, Mr. President.
You're welcome.
I think that does not contravene the Brown Act provisions. As a matter of fact, the statement that Mr. Parton cites talks about without consent of the board. In other words, his statement of the general rule has in it the exception for when permission is granted.
Yeah. And Tom, we had what I consider a breakdown of decorum at one of the meetings I attended for ABAC, and I promise I will never let that happen here. So I put everybody on a strict leash that they speak to the board, okay?
That's absolutely appropriate, and I have to do that myself sometimes.
Okay, thanks. Interesting point. I think we have your point. That was helpful for me, and I think we have other speakers. So thank you. Good to see you, Tom. Next.
My raised hand. Go ahead, Robert.
Where I'll recognize the phone one next. Go ahead, Keith.
Good morning, folks. I'm here speaking on behalf of
Introduce yourself, please.
Keith Lemieux,
Thank you, Keith.
and I'm here speaking on behalf of my clients only this time. You heard from Mr. Bunn. I just wanted to say that my clients echoed the analysis of county council on this. I appreciate Mr. Bunn's suggestion that the privilege could potentially be waived, I suppose, or extended. I would just point out that this body is not a government entity. What protects the board when they go into closed session on this is the common interest privilege, because this is an ongoing litigation. That same privilege would protect the information if it's transmitted from board members to their own attorneys. So, with Tom's suggestion, there would not be a waiver of privilege for that information. It would stay just as privileged as if it was only maintained in the closed session. What I would suggest is, I don't know if this has to be brought to the court's attention and straightened out with the judge, but I think just as a pragmatic solution, I would recommend maybe we have the attorney sit down and try to come up with guidelines for when the information could be shared. And I know I heard Mr. Parton's reservations about that, but perhaps with sufficient guidelines in place, everybody could be satisfied as a way of trying to resolve the issue short of a motion.
Great. Thank you, Keith. And there's somebody online that had wanted to speak.
Yes, Mr. Chairman, Robert Cush, and I'm counsel for Cajon Ranch.
Right, go ahead, Robert.
I wanted to say first and foremost that I agree with Mr. Parton's conclusions. The purpose of allowing a board to meet in closed session is so that they can speak frankly with their lawyer without fear that those conversations will leave the room. And likewise, so that the lawyer can speak frankly with his client without fear that the advice will leave the room. That privilege is subject to waiver if that information is distributed outside of closed session. We run into a real problem when we start allowing dissemination, and I'll use Keith's client as an example. There is a seat which is shared between several public water suppliers. When we say that the client can talk to his client or his lawyer outside the boardroom, where does that privilege stop? Does it stop at Palmdale? Does it extend to Little Rock? Does it extend to everybody who voted to put that person in the chair? Flip it around and look at the landowner issue. If who is Mr. Urosic representing, and who can he share that information with, and where does it stop? Can he share it with all of the landowners because all of the landowners have a common interest, which is separate and apart from those of the public water suppliers? So you get out on that slippery slope, and then you have a class of people in the basin dealing with effectively inside information that a large portion of the regulated community has no access to. And that goes right back to Mr. Powell's concern about due process. So we're either going to be open and transparent, and if the issue before the Watermaster is such that it can be shared outside of the closed session, then perhaps that it ought to be shared equally with all of the stakeholders. At what point do you say the information should be made public when you give it to a select few, but not all? So it's a slippery slope. I understand the conundrum, but I also think it's pretty easy to manage, and we do this as public lawyers all the time. We look at the agenda. If we've got a board representative, we review that agenda between client and counsel in advance of the meeting and share views. And those views and discussions have nothing to do with what's said in closed session. They have nothing to do with Craig's advice. And so I think we're trying to sort of solve for a problem that really doesn't exist.
I'm sorry, Henry. That's totally, yes.
Eric, you're on speaker.
Sorry. Somebody speaking that hasn't asked permission. Robert, thank you for that discussion. Did we close that off? Okay. Is there anybody else online that wants to speak? Okay, board discussion? No discussion? Okay. Moving on to the next item. Thank you, everybody, for all that information. I think it was helpful for us. We'll move on to item 11, discussion concerning section 18.5.13.2 of the judgment. Ray, de minimis use. Right.
I think 11 and 12 are kind of connected somewhat here. The administrator discussed the problems with the lack of production reports being presented by new production applicants.
Yes.
And what the nature of that problem was. Legal counsel provided some edits to the rules and regulations on page 44 of your packet that instead of requiring or invoicing the new producer who has not produced production reports, that was a mouthful, they would pay a fine of a certain amount, and the board was to consider what that amount would be. And in addition would have their application revoked. So we provided language to reflect that issue. There's going to be more discussion about that. I think it might be appropriate to have staff indicate what the problem was we were trying to solve in this amendment to the rules and regs. But what we would be asking, if the board agrees with this, is that we post it for public notice for a hearing in a month and adopt new rules and regs as edited.
Okay.
So, but Peter and Angel may have some insight on the need for this language on the behalf of the administrator.
Thank you, Craig. Peter?
All right. Thank you, Craig. Thank you, Chair Paris. So just to recap from our last meeting in March, I think that the key issues that this is solving for is you have, we were charging for replacement water assessments, maximum replacement water assessments, if someone was late in turning in their production report. So there, one is that somewhat disincentivizes someone from turning in a production report, especially if they haven't produced any water. So that really maximum penalty might be serving as a disincentive or a barrier for some of those that haven't put their well in yet to actually respond. Secondly, moving to a fine instead of replacement water assessments allows that money to be applied to administrative costs. When we're just doing replacement water assessments, you're essentially taking that money and passing it along to the Antelope Valley State water contractors. And very little of that is going back to the administration process. And it can be a costly administration process to chase down folks who haven't submitted their production report. So it's really reapplying the money to the appropriate bucket. And oftentimes, like if you flip it around and look at it, if money is going back for replacement water assessments for water that wasn't pumped, that also doesn't make sense. So this really, from an administrative perspective, trues it up so that the cost of pursuing non-producers turns into a fine, which goes back to the administration process and funds that. It still does not get them off the hook from paying their replacement water assessments. So they do need to produce their production report, and they'd still be responsible to pay all of their past replacement water assessments. So, and then that money would be appropriately placed. Let's see, am I missing anything, Angel? Oh, okay. So I'll just start with this one, just say we feel like this helps resolve that issue. Should get better compliance and should get apply funds in an appropriate way. On the de minimis, staff brought that up because it's in the rules and regulations or in the judgment itself. It allows to declare domestic water supply new producers as de minimis, and then that removes kind of like an issue of having to go back out and invoice these folks for what is not very much water, and then also not very much administrative return. It will be a drain administratively to pursue those single family home domestic suppliers. So, and it mirrors what other adjudicated basins do. Often they do not require the new invoices for domestic water supply. So we brought it up because it's in the judgment. It would clean up things from an administrative standpoint and allow for more focus on large pumping, commercial pumping that has a greater impact to the basin. But we know that the advisory committee has not been supportive of that, but we thought it was worth bringing up for the board to consider.
Thank you, Peter. Go ahead, Brendan.
Just a poor simple guy from Eastside Lake Test. Are you telling me that we're walking away from somebody's obligation to pay us because of the smaller bill? Simply put, I just want to make sure I'm understanding.
Partially that's true, but if we just look at it from the standpoint of what's really mostly the cost here is funding replacement water assessments. It is not necessarily funding the administration. So if a single family home produces 1 acre foot, and oftentimes when they turn in the production reports, it's much, much less than 1 acre foot. It's like 0.25 acre feet. What you're looking at then is you're going to get back like $2.50 in administrative assessments. That's it. And then you're foregoing the replacement water for that 1/4 acre foot on that property. So that's where the de minimis piece comes in. If the Watermaster engineer considers that total usage from the single family homes to be de minimis impact to the basin, then it doesn't need to be replaced. So then what we're looking at then is just strictly that administrative cost. Is the juice worth the squeeze to get back that administrative cost? And from an administrative perspective, we don't think so, but it is the board's prerogative.
Nice farming from. I gotta read this.
Go ahead, Drew.
So there is an administrative cost and there's an impact to the basin, right? And I think a major concern by the magnitude of this basin and the number of de minimis users, the cumulative effect of that could be non-de minimis, meaning that how does the Watermaster manage that, right? Where all of a sudden one day we wake up and the de minimis amount is more than any Exhibit 4 member or any member that, is represented, right? The cumulative effect of that. And I think that is, from a number of the landowners a concern is, and I fully understand, chasing the administrative costs, but I think we need to discuss what that looks like. And I know, the Watermaster engineer feels like we haven't hit that point. I think we're concerned, at least I am as a board member and some of my constituents, that, we're not having the foresight, we're not thinking about that and how we manage that from a safe yield.
No, I totally understand the concern over that. We wanted to bring it up because it is an opportunity, and it is within the judgment. It does reflect what other basin practices are. And there's probably now would be the time to make a decision one way or another as we're considering these new producer changes. But we respect the board's opinion if it comes to not pursuing the de minimis.
So there's no decision we have to make today, right?
No.
And what we're being asked to do is just put it over for public comment and then board input before we change or do anything. Is that correct?
If the board votes to approve the amendment, we would set it for hearing in 30 days.
So today
if the board isn't going to approve the amendment, there's no need to give public comment on it. There's no action we've taken that the public needs to comment on.
Okay, I just want to jump in real quick. Craig, I don't believe the memo speaks to the de minimis piece, correct?
Right.
Okay, so that would strictly, the memo is strictly about changing over to the fine system.
Right, and the revocation.
Yeah.
Which I don't have a problem.
No,
with the-
okay, so that's not the problem. The de minimis issue would come up, may or may not come up, or you want it to be put in now, or what are you?
It's at the pleasure of the board. If the board wishes to consider it, I think put it on for a future agenda item. Otherwise, I think we've done our due diligence and that we've looked at the judgment, we brought it to your attention. And if it dies here, then I think we've followed the process.
My opinion, I think it's something that needs to be discussed and vetted. And love to hear comments from the advisory committee on it.
Yeah.
Go through the process.
Agreed. And have we been combining 11 and 12? It sounds like that's what we've done.
We did within this discussion, but they were separate. So
Yeah.
12 is I believe
12
that's our
stands
memo.
on its own.
Yes.
And now we've heard the de minimis and 12. Now we can finish up with where we're at with 12.
Correct.
Right.
Right.
And the de minimis is something put on the agenda, take it to advisory, let's get their input, and then we'll consider that at a later date. On 12, you want action if we have consensus to approve 12.
Approve the amendment to regulation 14.0.
And then we would set a public hearing to get more input. Correct?
Right, it's the last paragraph of page 44. The board decides to approve the amendment as proposed. We request that they decide on the amount of the proposed fine, which will be incorporated into the amendment for hearing on adoption at the next meeting.
And what is the recommendation for the proposed fine?
Staff's recommendation was up to $200. I know that that's less than what the advisory committee has been pushing for, but that would sufficiently cover any administrative costs. It was up to the full replacement water assessment value as a fine.
I do want to point out that in our packet, it does say that the committee does not believe that the revision is ready to be scheduled for public hearing. If that was your question.
Yes, that was my question. Dennis? What does the advisory committee suggest on this and for action taken? And just give us advice.
You look on page 28 of your packet.
Yeah.
There's a few questions and ideas there. The one idea that Peter mentioned of collecting an amount equal to what the approved production is and not calling it for replacement water. It would be a deposit for administrative costs. Another idea was to collect that much plus some additional amount for administration, which if the staff was able to get in contact with the producer, that would leave some money that could be shifted to replacement water if that was confirmed. And just questions about the authority. Can the Watermaster place a lien on properties for these kind of things? Are there other ways to get enforcement, like forcing some kind of a smart meter to be put on these wells where it could be read remotely by the staff?
At the owner's expense.
At the owner's expense, yes. So those are some of the suggestions that committee had.
Great. Thank you, Dennis. I appreciate that. Board, what would you like to do?
So I have concerns that we're not ready for this revision to be scheduled for public hearing. So I would propose that some of these comments be considered and articulated by staff, administrative staff, and put forth so that we can actually act on whether it should be ready for scheduling for public hearing at our next meeting.
Okay.
I agree with that.
Okay, I think we have consensus, so let's put this on the agenda for the next meeting and recommendations from both administrator and council as to you can do 1, 2, or 3, give us some options, and then we will, based upon what you're hearing from the advisory committee this time and next time, and then we'll be ready to choose 1, 2, or 3, or maybe punt and not do anything.
Mm-hmm.
Okay? Great, thanks. Is that fine, board? Everybody good?
Works.
Okay, that brings us to number 13, consideration possible action on new production applications. Arden shall go.
Hi, good morning. So the first application that we're considering today is for Mr. Chilens and Ms. Jimenez. And this is requesting 1 acre-foot per year in the West Antelope sub-area. One difference in this application is that there's an existing well instead of drilling a new well. So the party would need to intervene because the property was not included in the adjudication process, but is improved, and it does not qualify as Willis class. In the discussion with the advisory committee, as mentioned earlier, there was a concern that there's a covenant included in the application that mentions farming on the property without specifics about that. That was incorporated into the water demand calculation. So the water demand was from Antelope Valley Engineering, an estimated 1 acre-foot per year for a single-family home with farm animals and some trees. And so hearing the recommendations from advisory committee, we would recommend that we just get a little bit more information from the applicant and a detailed breakdown of the water demands from Antelope Valley Engineering, and either provide more information or an updated water demand estimate. But we did not find potential for a material injury for the 1 acre-foot per year. And I'd like to invite any comments or questions.
Isn't the applicant online?
Hi there, this is the applicant, Amy Jimenez, and my husband's here as well. So we can answer any questions for you guys.
Yes, there's a little bit of confusion because of that farming term that was on the application. From the looks of where you guys are located in the satellite view, I really don't see you guys doing any farming at that location. But
yeah, so to give you a little background on that, my grandfather, Bill Barnes, he was a dry farmer. So we actually purchased that land from the family trust. The well was already existing. When I went to regional planning and had talked to Christina Colon, who is the one that typed up the and tying all the lots together, I don't know if she was confused. You know, told her about the property, and what we were going to do is just put a manufactured home on there and have some domestic animals. I'm not sure why she wrote that on the covenant, but we're not going to be doing any farming. We're not going to have farm animals or anything like that. So it is just for a single family residence, and that's it.
So it was the county did that?
Yeah, Tina's the one that wrote up that covenant. And initially when we started this process over a year ago, we didn't have the APN. I just got a letter last month showing that we had the lot tied and we had a new APN. So there's been a whole lot of confusion between the county and all the different departments. And I've been doing everything myself. I work for a contractor. So I've been doing all this stuff myself to stay in the loop with it, and did not catch that description that she had written in there about farming animals and that other stuff. Angel was actually the one that brought it to my attention yesterday when I had emailed her.
Okay, thank you.
So, Arden, you want to comment on that?
Thank you so much.
Thank you very much. Arden?
My only comment is that given that there's not additional farming, and especially without water for the animals, 1 acre feet should be more than enough for a single family home and the small amount of landscaping that they proposed in the application.
Okay, and the advisory committee did not have that information yesterday when they, or the other day when they voted on?
They did not have clarification
Okay.
on how that farming term got put in there in the advisory committee. There was a good catch on there, but it was not the applicant, it was the county that did that.
Understood.
Therefore, I didn't plus be right next to the
So no.
I would note though that while it was drafted by regional planning, it was signed by the applicant. I just want to be clear that it wasn't done without the applicant's knowledge, the homeowner's
Stated.
knowledge.
Okay,
I understood, but I can't see a reason to deny it, so.
got it. Okay, so Arden, you've heard the discussion. Is this one you would recommend approval on?
Yes, sir. We'd recommend approval.
Okay, and Dennis, you've heard everything. You're good? So Dennis is shaking his head up and down, meaning yes, I think, right? Okay.
Mr. Chair, I recommend approval of R 2518.
Motion made, second by Kathy. Motion made and second to approve R 2518. Any further discussion? Any discussion online? Hearing none. All in favor of the motion to approve resolution R 2518, say aye. Aye. All opposed? Motion's carried unanimously. Thank you, everybody. And let's move on to item B, R 2519. Go ahead, Arden.
Thank you. So this application is for Ms. Delgadillo, and it's for 0.25 acre feet per year for use of a single family home with a very small plot of landscaping. And this was approved by the advisory committee unanimously. And we also recommend it for approval.
Okay, any comments? Anybody online? Seeing none, is there a motion to approve resolution R 2519?
So moved.
Motion made by Kathy, second by Brandon. Is there any discussion? Hearing no discussion, all in favor of the motion to approve resolution R 2519, say aye. Aye. All opposed, motion's carried. Starting to sound like an auctioneer. Next, item C.
So this is for Mr. Vilka Inga, and it's for 1 acre foot per year. This is a single family home with fruit trees, a garden, and a small amount of livestock, estimated at 1 acre foot per year. And this was also unanimously recommended for approval by the advisory committee, and we found the potential for material injury to be negligible, so we recommend it as well.
Great. Any discussion by the board? Any discussion online? Hearing none, is there a motion to approve resolution R 2520?
I'll make that motion.
Motion made by Derek, second by Kathy. Any further discussion? Hearing no further discussion, all in favor of the motion to approve resolution R 2520, say aye. Aye.
Aye.
Aye. Motion's passed unanimously. We're now on R 2521. Go ahead, Arden.
Thank you. For the 4th out of 4 new production applications this month is Mr. Rubio, and this is for a 1/4 acre foot per year as well, for domestic use for a single family home with no irrigated landscaping. Once again, unanimous recommendation for approval by the advisory committee, and the potential for material injury determined to be negligible on our end.
Great.
Arden, I have a question for you on this one. We brought up some concerns about the central sub-area basin in the last meeting. I know we're gonna have a report from you in a little bit on that. And I know it's only 1/4 acre foot, but you guys have taken into consideration our last board meeting, the comments and concerns that we have on water levels in the central sub-area basin, correct?
Correct, yes. And I'm double checking the map here, but yes, this is in the portion of the central Antelope sub-area where we have seen the increasing water levels in recent years.
Okay.
Good answer, Arden. Any other questions? Hearing no further questions, is there a motion to approve R 2521?
Make the motion.
Motion made by Derek, second by
Second.
Kathy. Any further
The
discussion?
way everybody's second.
I know, I'm waiting, thank you. So motion's made and second. Is there any further discussion? Hearing no further discussion, all in favor of the motion, say aye. Aye. All opposed, motion's carried unanimously. We're now on item 14, consideration possible action on transfer application. Go ahead, Arden.
Thank you. So the first transfer is from John and Adrian Recca to Metler Valley Mutual Water Company. And this is for 47.37 acre feet, a one-time transfer to cover replacement water assessments. And so one item that's discussed in the letter for this is that Metler Valley recently, in this past year, installed a new flow meter. And in the past, their reported production from their well has matched the sum of delivered water. However, this year, the flow meter recorded 71.81 acre feet, but the sum of the residential meters were 37.17 acre feet. And they calculated 47.37 acre feet from the average of their pumping rates. And they've been in a lot of communication with Watermaster admin staff and the engineer as well about how to proceed. And so they are getting their meter tested. And so to see if the 71.8 was accurate or if it's more appropriate to use their estimated amount. So this is for the estimated volume based on their pumping rate, which is about 10 acre feet higher than the sum of the residential meters. If they find with the test that the volume, the 71.8 acre feet per year is accurate, they will pay for the additional 24.44 acre feet. We note that there is that well that has shown declining water levels in this vicinity in the southern portion of the West Antelope sub-area, but we observed with the recent USGS measurements, the great news that for the first time since about 2007, water levels from 2024 to 2025 did not decline in that well, which suggests that the likely illegal pumper in that area that has been causing the water level declines has either decreased or stopped production in this area. So given all of this and the understanding that if their flow meter is shown to be accurate, and they did pump 71.8 acre feet in this past year, we found that they would pay the replacement water assessment. We found the risk of material injury to be negligible. And this was unanimously approved or recommended for approval by the advisory committee. Are there any?
I'm sorry, Arden. You're recommending approval?
Yes, sir.
Okay.
And Arden, the water's going from the central sub-area basin into the west sub-area basin.
Yes,
correct?
that's
Which is a good thing.
I recommend approval of our 2522.
Motion made by Brandon to approve resolution R 2522. Is there a second?
I second.
Second by Carolina. Is there any discussion? Hearing no discussion, all in favor of the motion to approve resolution R 2522, say aye. Aye. All opposed, motion's carried unanimously. We're on R 2523. Go ahead, Arden.
Thank you. So this is a transfer from Gary Godey to East Union School District. It's a permanent Exhibit 4 transfer of 1 acre foot per year and a one-time carryover transfer of 206.95 acre feet. And both of the parties are in the Central Antelope sub-area. So Eastside School District has been pumping without a right in the Central Antelope sub-area and has been working to get in compliance with the Watermaster. They were approved for new production last year and are in the process of intervening. This transfer would cover the replacement water obligations for what Eastside School District produced in 2016 through 2022. In the new production application last year, we reviewed in detail the potential impacts of their past production and continued production, and did not find the a high risk of material injury. So this application was recommended for approval by the advisory committee with 1 abstention and also recommended by the engineer. Are there any questions?
Any questions, board? Any questions online? Seeing none. Is there a motion to approve resolution R 2523?
I move.
Motion made by Carolina. Is there a second? Second by Brandon. Any discussion? Hearing no discussion, all in favor of the motion to approve resolution R 2523, say aye. Aye. All opposed. Motion's carried unanimously. We're on item C, resolution R 2524. Arden, go ahead.
Thank you. So this transfer is related to a property sale from Northrop Grumman to Key Wind LLC. It's for 2 acre-feet per year and 13.28 acre-feet of carryover water, which is all of the carryover water that Northrop Grumman has. Because this is related to a property transfer, there is no material injury analysis required for it. And this was unanimously recommended for approval by the advisory committee. Any questions?
Any questions?
No.
Any questions online? Hearing no questions, is there a motion to approve resolution R 2524?
So moved.
Motion made by Kathy.
Second.
Second by Carolina. I was looking at her. Sorry, Jerry. Is there any further discussion? Hearing no further discussion, all in favor of the motion to approve resolution R 2524, say aye. Aye. All opposed. Motion's carried unanimously. We're now on item 15, consideration and possible action on non-production well application. And that should be Angel's show. Bye, Arden.
Thank you, Rob. This month, staff received one non-production well application from the applicant MKK Properties. They are requesting to drill a test well at the Winter Haven Mobile Home Park located on Avenue D and 185th Street West. The test well will be used to assess the aquifer depths, production rates, and the arsenic concentrate, and that data will be used to design a replacement well. Once the tests are complete, the applicant has stated that they will promptly abandon this test well. They will also submit a application for the replacement well once that time comes. Staff recommends approval of this application, and so did the advisory committee.
Great. Thank you, Angel. Any discussion? Hearing no discussion, is there a motion to approve resolution R 2525?
I move.
Motion made by Carolina.
Second.
Second by Derek. Any further discussion? Hearing no further discussion, all in favor of the motion to approve resolution R 2525, say aye. Aye. All opposed? Motion's carried unanimously. Now I'm going to give you a change up, Peter. We're going to go back to item 12. C, the revised new production application detailed responsibilities. I overlooked that. So will you re-discuss that and tell us what action you would like?
Yes. Thank you for, I think it was Patty catching it for us there. Appreciate it.
It takes a village, Peter.
It does, especially to keep me in order. So staff put together a sheet that would accompany a application for new production.
This is on page 46, correct?
Yes, thank you. On
You're
page
welcome.
46, it covers all the responsibilities of new producers and provides a spot to initial those and sign, and it requires notarization. And this needs to be complete when it comes back with a new producer application. The thinking here is that if they are aware of all of these things, then they'll be more responsive when we reach out for production reports in the future, and they won't be surprised by the consequences of failing to turn in their production reports. This has been put together by staff, but also with feedback from general counsel and the advisory committee. And I believe the advisory committee was in support of it in its current form. So if the board's in support, we look for a vote to allow staff to include this in the new applications for a new production.
Okay, and council, you agree?
Yes.
Okay.
So I think
Discussion.
I'm confused because I'm looking at page 28, according to the advisory committee, are we talking, can you repeat, are we talking about item 12, which, C?
12C.
Okay. Thank you. I just want to make sure that I understood which you're talking about before we move.
Now we're talking about item 12C. It's a revised new production application of detailed responsibilities. It is on page 46. Staff is recommending approval. Council concurs. Is there a motion to approve? Wait. The revised new production application. So moved by Brandon, second by Kathy. Is there any discussion? Hearing no discussion. None online. Is there a motion to approve item 12C, the revised new production application? All in favor of that motion, say aye.
Aye.
All opposed. Motion's carried unanimously. Thank you, Patty. Did I get that right? Thanks. Now I'm going to do a change up. I have a client call I have to take at noon. Drew Mercy is here to be my alternate when I do that. I would like, and we still have time, I would like to change up our report so that I hear the general counsel's report first, because there's some items I want to participate in that for sure. And that's a change up to both Peter. I guess that's going to mess up our slides too, right? We're going to be able to.
We can work through that.
We can handle
Yeah,
that.
we can handle that.
And Craig, take
Sure.
a deep breath. We're going to go to you in a minute. Are you ready?
Yes.
Okay. So let's go to the general counsel report, item 18, and then we will go back for 16 and 17. And why don't we go ahead?
Right. In terms of update of activities, they'll be covered in the closed session in general.
Thank you.
But the Rancho Sierra properties, we wanted to give some information concerning what's going on to the public. If you recall, we have a judgment lien against Rancho Sierra properties of approximately $475,000.
And Rancho Sierra Properties is now abandoned golf course out
Correct.
on the east side.
Correct.
Okay.
We have been in the process of discussions with various parties concerning their interest in bidding for the property and acquiring the property. We have got 2 offers on the property. I think what we're interested in communicating to the public is we have 2 offers, what the amount of those are, who the parties are that have made the offer. And in closed session, we'll consider any counter offers or additional offers in the time for closing the period in which we'll consider offers.
So we would consider, in closed session, we'll consider the process we will set up to make this a transparent, I guess, discussion and everyone being able to participate in this. And if I can clarify, we have the current landowner and her attorney cooperating with us in this process. Is that correct?
Correct. And we have two offers on the property that I would like the public to be aware of in case there's interest in anyone else participating in making an offer.
And then in closed session, we will go forward and set up some type of process and announce it to the public.
Correct.
Okay, go ahead.
Correct. So we have an offer of $151,778 from the city of Lancaster. And we have an offer of $151,777.77 from Mr. James Yellen. Those are the 2 offers that we currently have.
And do you want to discuss that appraisal has been done on this property, or is that something you want to wait?
And prefer we just leave it. That's the information I want the public to be aware of.
Can you give me those numbers one more time?
151,778 for the city of Lancaster and 151,777.77 from Mr. Yellen.
And that's all the information you want to provide at this time?
And open it to any public comment that public wants to provide to us, but I would ask the board to have their internal discussion in closed session.
And the plan is not, just so the public's aware, we're not opening up bids right now and hear that online. You're going to recommend a process to do something like that.
We'll recommend a process. Right now, it's just letting the public know what the status is of the property.
Good, because I don't want to be an auctioneer today. So
You're not.
Go ahead.
I've been around the block a long time. I've never seen somebody come within 23 cents.
Yeah.
That begs the question on how that happened.
Well, I think also it's going to be opened up to the public in a process so that those discussions can be done in closed session. Any other?
If there's no comment from the public, it's just a matter of information.
Okay, great. Then go to item C, please.
C is the draft carryover memo template that we did at the request of the board last month. I understand it's gotten substantial discussion, questions, concerns about it. It's on page 217 of your board packet. We attempted to mirror what the judgment rules and regs say, but you'll notice from the advisory committee that there's a number of concerns raised on various issues with that template. I think at this point, what I would recommend the board consider is appointing an ad hoc committee to work on this issue so that we make progress according to the board's direction on it. Some of the objections were that this effectuates essentially a taking of people's water rights. Certainly not an intention to do so, but we are also responding to the board's concerns about what happens when there's a call on carryover by everybody at one time, what kind of catastrophic results that could be, and should we put reasonable or any guardrails on the carryover that can be stored for a period of time.
Well, I think that we have a guardrail in place, and I'd love to hear your comment on it, but it's the material injury analysis. Speaking as somebody that's transferred a fair amount of carryover water and dealt in this, you still have to do material injury analysis.
Correct.
So, for example, I think District 40 has the most carryover water right now in the tens of thousands of acre foot range. That doesn't necessarily give them the right to just go pump that at will. There has to be a material injury analysis, and arm to the basin is looked at that, and there's a process on that it ensures that we don't overdraft one of the sub area basins or the whole basin in its entirety. I mean, that's kind of the way that I look at it. I'm not sure that that's the right perspective, but it does make sense. As far as the taking of water, when I look through that judgment, I've read it a few times. Obviously, I'm not an attorney, but you look at it, and I don't see where there is the ability for taking of water unless somebody just fails to enter into a storage agreement with us. That doesn't necessarily mean they have the right to pump it at their will. We still have ultimate authority through the engineer and their analysis.
Right.
I have
the judgment talks about the importance of the Watermaster board maintaining the balance in the basin and protecting the native safe yield. I think this was drafted with that construct in mind, that we have discretion, the board has discretion to take reasonable measures to protect the basin if there is a threat to it in any sense. So I think there is discretion to do it. I also agree that the material injury analysis is a substantial protection of that discretion of the board. But I defer to Arden in her comments on what carryover unrestricted poses for the basin in the future.
Mr. Chairman.
Go ahead, Caroline.
Thank you. So first, I want to thank Craig, council. This was a tough thing to initiate, and it was done at the request of this board. And I think it is still very important. I'm really glad that we agreed to have you do so first time out of the box. So I think it's well understood that there was going to be comments or clarification needed. So thank you, first of all. And then second, Craig, I do have some other comments specifically about the memo and the carryover agreement, but I'm more interested, I think maybe those can be held, if we could hear more about how the ad hoc that you're proposing or recommended for our consideration might work, so that that might be the appropriate place for everybody to.
I noticed there was a huge amount of pushback on the template. And I just think two members of the board with someone from the advisory committee or two people can streamline it. We can have every other week phone conference to hash out something that is more acceptable and recognizes the concerns that are brought out. I just don't want a month to go by just legal counsel amending it, thinking I'm getting this right. And then we're back in a month with more questions and concerns. So,
this could be a subject, and that's why I wanted to expedite this. This could be a subject that could be a whole special meeting or two or three. I think we need to hash it out. I've talked to Craig about it. There's a lot of moving pieces to this. And Craig and I talked about who would be good for an ad hoc committee. The chair has the authority to give to appoint an ad hoc committee. And I've done that in the past. I'm going to give a recommendation. I would like to check all of everybody's input, but I think, Carolina, I'd like you on the committee. LA County has some of the highest carryover. Brandon, you have a lot of knowledge on the carryover and transfers of carryover and stuff. So from our group, public water suppliers, landowners, the two of you, and Dennis, I would like either you on the committee or for you to recommend a designee that would, it seems that as the chair of the committee, you would be one that would have the greatest input by your committee, unless you would have a different recommendation. And I know I just surprised you with things, and I'm sorry.
I was thinking 3 times I was lucky. Here we are at the 4th. I can certainly start that, and then we can, when we have our next committee meeting, we'll talk about it some more. It might be more than a month, but we've got till the end of next year to get this figured out.
Yeah, and I would like maybe you to, I would like you to kind of take the laboring order, work with Craig to schedule, it can be Zoom meetings. I want you to be giving input to the advisory, the two of you giving input to us. And I expect that once this step starts taking shape, that we would expect to have, a special meeting or two with public input. The only other thing, Arvin, are you listening?
Yes.
Yeah, I had a request by one of our board members at AVAC, and I think it's probably a good thing for us to do. Do we have the ability to break down the difference between production carryover and return flow carryovers?
We could do that. I believe that the inputs that go into our calculation of the age of the carryover water begins with the values directly on the tables that are carryover from imported water return flows and carryover from production. So I think we'd be able to calculate that with too much effort.
I think that was a request made by one of our board members. I think I would concur with that, and I think that would be good information for the ad hoc committee to have any issues with that board?
It's information that we need.
Yeah, that's what I'm thinking. So that's my only other request. So, Craig, do you want me to do a motion to set up the ad hoc or just take my, as chair, set it up?
If you can do a motion, I like the formality.
Okay.
May I get some input before that?
Yeah, absolutely, Derek.
So I mean, an ad hoc, and if I understand this, will not be a public event, right? So I'm typical of ad hocs, they're not public, so it would be the people that are asked to be part of that ad hoc.
And we can do it any way we want. I think we need a lot complete transparency on this. So I would say, let's let the ad hoc with Craig come up and propose exactly what the process is going to be to us and give us input. My idea, I know you were on an ad hoc with Adam at one time on our, we made it for our administrative ad hoc at the beginning.
Well, that wasn't an ad hoc, that was a subcommittee where we did have public activity.
Subcommittee,
Yeah,
you did.
So that is where I'm trying, my only comment back is, I think if we're talking about expedition and transparency, I think making it a public opportunity, even, board member, and I don't know, the council. But my question is I want to make sure we're up to speed and the public's up to speed, so action can be taken versus the iteration we tend to go through is. I hear what I'm saying.
I'm good with anything as long as there's a consensus of who I'm appointing and that we'll make a motion of that, then I'll let the three of them work with Craig on the process. I could even foresee a process of a Zoom meeting once every 2 weeks, set up agenda items, invite the public if they want, but the idea of the ad hoc is not to bog us down here for several meetings while they're working out the details. Would that be okay? Go ahead, Carol.
I was going to.
I just have some concerns.
Yeah, what suggestion?
Yes.
That council do a memo setting forward the process, how often we suggest meeting, the context, so you have some detail of what.
And let's do this. We have a little time.
Yeah.
My proposal will be this. I don't think we have to take action on it now because the advisory committee should weigh in, but my proposal is the ad hoc. I told you, Brandon, Carolina, and Dennis, and that council will put together a process for us to weigh in next time, and let's take action next time. I don't want to surprise anybody. This is a very important issue. And Drew, would you come up and take my seat, please? And Kathy will now and we're going to take a 5-minute break. Drew will take my seat. Kathy will take over as chair, and I'll be back as soon as I can.
Who's leading? Kathy. Kathy.
I'm ready to go.
Boss lady, let's go.
Okay. Hello? We are going to, I've gotten the rule that we must begin. It's 12 o'clock. And are you done with your general counsel?
Yes.
report? Okay. Then we will go to item 16, the administrator's report. Take it away.
All right. Thank you, Chair McLaren. We will move on. Let's see, Holly, can you go ahead and move us to the next slide? Just want to give a quick update on administrative activities. Really focus on May. We're going to have an audit that'll be before the board for approval. That's been moving along well, and Teresa will be presenting that. We're also going to begin our collections for replacement water assessments and variable assessment invoices. So that will, back to Director Hernandez's question earlier on the budget, that will complete essentially our collection of revenue for the year. And then Teresa is also going to present on consideration for certificate of deposits for surplus funds. She believes that there's a better way that we can yield money off of all the money we have in our accounts, and she wants to present that to the board for their consideration. So those are the things that we had. We also, Patty's diligently put down on her notes all the things that we'll bring back to the board based on discussions today. So May was looking light, but I think it's going to be a busy month for us. And then we'll move on to the next. And just want to note that there's a staff report on page 200, and it covers basically it goes to some background on administrative efforts to make contact with delinquent new producers back in 2024. And also goes over their responsibilities and consequences under the current rules and regulations for not turning in your production reports. And then we also consulted our consultation with counsel over what's the process now if we apply the rules and regulations. And so that results in a revocation of the rights of those new producers that have just failed to respond. So on page 201 through 203, you'll see a list of the new producers that are having their new production rights revoked. And that's a total of 106 acre feet of revoked rights. And while it doesn't call it out specifically within the rules, I think as a part of like administrative or Watermaster engineer process or council process in the future, these are parties that we should look at when we're auditing for pumping outside of the judgment in the future. So we know the parcels, we know where the wells were supposed to be located. When we go back and do an audit of illegal pumping, these parcels and people will come up during that consideration. So it's just a part of the administrative process. It happens automatically, so there's not anything to be voted on here, but we're happy to take any questions you have at this point.
Any questions?
All right. And that concludes my report.
All right, thank you. Now we'll go on to number 17, the water engineer's report. The Arden show, as Rob says.
Thank you. I will share my screen and let me know when it looks good. Can y'all see this?
Not yet.
Not yet.
All right, let me try that again. All right.
Yes, now we see you.
Yes, okay, and you see like the full screen presentation?
Yes.
Okay, perfect. So our first item A is the summary of new production and qualified small pumpers. I just added the note that this does not include the 106 acre feet per year of revoked rights that were just discussed by the administrator's report. We note from last month to this month, there were 2 acre feet per year that were added. Are there any questions?
No
Here.
question.
Thank you. Hearing none, on to item B, which is a continuation of the discussion of water levels in the Central Antelope subarea. And this is follow-up to our discussion last month, specifically about water levels that were near the Air Force Plant 42. So this is near, this is the U.S. Air Force Plant 42. There was recently an application to install new monitoring wells because water levels had gone below the depths of the existing wells. And so the question was, can we look at water levels both in this area and in the Central Antelope sub-area to look at the trends? And so I shared this map last month, which the green dots are where water levels are increasing and the red dots are where water levels are declining. And we looked closely at those 3 red dots, which are near Plant 42. So one of the questions that came up is, well, who is pumping in this area? How close and how widespread is this? And so one thing that we did look at in this area are these 3 monitoring wells showing declining levels. Are they screened in the same area? And we did find a range of several hundreds of feet, the differences between the depths of the well at Palmdale versus the one slightly north of it. And a really good indicator of what's happening with depth are the group of nested wells slightly northwest, which this figure doesn't fully show how their water levels over time vary. But some of them are really sensitive to pumping going on in the area, and we can't even identify a trend. Others are relatively stable, while slightly to the east, we see that there is a slight decline. So that gives us a sense that with different depths and different layers of the aquifer, the water levels may be responding differently. When we looked at who is in this area, this is a plot showing the wells in the vicinity of Plant 42. And this is by APN, so parcel numbers. So it's worth noting that there may be multiple wells on one parcel that's just showing up as one dot in this map. But the blue triangles are U.S. Air Force wells. And we note that there are 15 active Air Force wells on Plant 42's property. And that produced a total of 479 acre feet last year. So this monitoring well this is the dot showing the 11 of the monitoring well. This is near several active Air Force wells, which recommends that or suggests that some of the production very close by may be influencing the water levels at this well. For the one to the north, we don't exactly know how widespread the trends at this well and at this depth of the declining water levels are. Also on this map, I'll go back to just the producers. There's quite a bit of public water supply wells shown in yellow. And then in purple are agricultural, industrial, and other supply wells that we see. So there is quite a bit of pumping that's occurring. And we do see sort of changes in trends based off of the depth that the wells are screened in. So are there any questions about this or items that would be worthwhile to look into more?
Arden, do you see the green dot number 16?
Yes.
Okay, I'm familiar with that monitoring well. There was a substantial reduction in pumping in that area by that monitoring well. So that makes all the sense that one's in the green. Obviously, you can't speak to the red dot number 11 because of the limited access to that site and what they're doing. Number 13, yeah, that one being in red, there was some pumping put out there that hadn't been out there before with some solar projects and different things out there. So I'm looking at this and seeing a trend of a potential issue out there. You know, obviously you have the red dot on number 18, and there were some more red dots going north. So I do have some concerns about what's going on in the central sub-area basin, especially as it is to all these well clusters in that area. And it's something that I think we need to continue to monitor very closely to make sure this problem doesn't continue to get bigger and turn into a very serious issue.
So, am I seeing a blue dot? And I don't know if that's 26 or 27 over there.
Yes.
So, you know, it's interesting that we have a red dot, and you just mentioned it, Brennan, at 18, and then you see something blue. So what's the disparity there between those two?
I think that what might be happening is that these are screened at different depths, because this doesn't show all of the trends in that cluster of, for example, 26 through 29. Those are all nested wells. And so they're showing different water levels and different trends with different depths because they're monitoring different aquifers. They're divided by clay intervals. And so some of them might be feeling the impacts of a nearby well that's screened in the same depth, the same aquifer unit as the monitoring well, while a higher up or lower down monitoring well might not be feeling that influence at all because the water isn't being extracted from that aquifer unit.
So I think that's important for us in just understanding this. We can't just look at it as red dots and blue dots. And so I just wanted to hear you point that out because if we're going to dig into this deeper and truly understand what the gravity of a potential issue is, that does need to be considered.
Mm-hmm.
The depth to ground and where it's being screened.
I agree with that.
I don't have any further questions.
So are there specific questions with this area that we can help answer now, or is there a broader desire for sort of regular updates or just keeping an eye on wells in this area?
Just keeping an eye, from my perspective, it's just keeping an eye on it. But also, I would go back to what I brought up several times and I was going to bring it up for a future agenda item. It would be nice to know what it would look like to get the beginning bounce by sub-area basin from you guys. I understand that you guys don't have that, but with the APM numbers that have to be given through all the transfer applications and everything, I believe the information is there. It's just a matter of how to get it. And I know I would like to hear from you guys what it would take to get that information and the cost associated with it in a future meeting.
And that's actually the perfect segue to item C. In the board packet, we have written a memo that sort of outlines our preliminary perspectives on what it would take in the consideration of looking into the proportion of the total production rights by sub-area. And there's also a memo from council it's under the Watermaster engineer's report. But a brief summary of what we found in our memo is, the first one is that there's different relationships between the sub-area boundaries and the groundwater flow. And by that, I mean that the boundaries between some sub-areas do serve as a physical barrier to groundwater flow. For example, between West Antelope sub-area and to the north, Willow Springs sub-area, there's a series of faults that appear to be causing water levels to the north in Willow Springs to not have a strong impact on water levels to the south in West Antelope sub-area. So we call that a hydrogeologic barrier. But we see from the West Antelope sub-area in the northern part going into the Central Antelope Valley sub-area that when groundwater levels increase in the west, it appears that then with a little bit of time, there's an increase a little bit to the east in the Central Antelope sub-area. And we believe that these are pretty connected. We also note, as seen with the Central Antelope sub-area, the groundwater level trends are not always consistent. And sometimes material injury analyses need a more localized scope than the sub-area scale. So we do just want to be mindful that when considering the sub-area wide scale, we're not overlooking or distracting from the local impacts that might be occurring. And in the memo, we have a time and cost estimate, which is pretty rough, of the time it would take to analyze the production over time for parties who have wells in multiple sub areas, and also a review of the allocation phase of the adjudication to be able to calculate the initial production rights by sub area. Yes, are there any questions, or Director Calandry or Council, would y'all like to add anything?
When I read the memo, I didn't see where you guys got to the point of what the cost would be to break that down.
I don't see that either.
Did you guys come up with that, or is that something you need to do in the next meeting?
Yes, and I'm going to stop sharing my screen so I can pull up the memo. So we estimated about 25 hours or $6,000.
I personally would like to just, hear some feedback from the advisory committee on whether or not to use Peter's eloquent term, if the juice is worth the squeeze for the project, to see if we want to spend the money or look at spending the money for that. Looks like Mrs. Kyle's coming up for a comment.
As to section 1.5 of the phase trial. In phase 2, it was discussed that all areas within the basin are hydrologically connected in one single aquifer. So how does that play into looking for a breakdown? Because we weren't separated by acre foot in each sub area when we were in trial.
The question that came up and the way it was kind of started was, obviously, and you know better than a lot of people, we had to go through the prove up period by the sub area basin. In the judgment, it talks about sub area basin management. So while I would concede that we are one aquifer, there is language in there that talks about sub area management basins. I know Director Rossick had brought that up in the past as well. So it's more of putting the information together with any potential risk of a particular basin getting into overdraft.
Right.
When you look at it, you and I both know, I mean, at one time we had over 70,000 acres of alfalfa being grown in the Antelope Valley. I would question whether or not we're at 6,000 today. So there's been a substantial reduction in water usage throughout the valley, but most of that is consistent in the West Sub-area basin. And when we went through our prove-up period for the water rights, you had to go through by APN number, which is also why when we do a water transfer, we have to submit the APN number, the origins of that water, and all the documentation that goes with it. It was brought to my attention, and I can see some value in having the discussion on what the beginning basin balance was by sub-area basin from the start of the adjudication. It's not something that I'm going to say it's a hill to die for, but it's definitely a discussion point.
And the other question I had was in regards to, as Arden said, you could see a dot on the page that didn't indicate one well. So are the well fields, once again, are they close together so you're creating a drawdown? I mean, that's a big thing. So that just for your information.
And it's just as much managing the basin as a whole, but also area specific. And when you're doing some of these material entry analysis, being aware of where we started, where we're at, and what's happened, I think is a good path to giving us a greater detail on our material injury analysis.
It is, and I don't know, to what extent other people have their wells tested. I would imagine that Bolthouse has their wells tested, and they're looking at those levels, and I know that we do, and our levels are up, and they have consistently come up. But there's out where we are, both locations, there's such a reduction in farming too. That, I mean, it just stands to reason it's going to come up.
And while it is going to come up, and while I would say that, speaking of where you guys are at on the far east side is one issue, as opposed to certain home developments that have just gotten approved in a centralized area.
Right.
I mean, you're talking about several thousand homes being approved now.
Right.
One of them in particular was 1,700 homes in one area. So I think it's very important for us to have the information.
Yes.
But I would also concede that if there's a major outcry about overspending the money and not seeing the value in it, okay, but we need to have the discussion. Right?
And just for some of the farmers, Bolthouse being one, us being one, our farm grounds are there's so many miles apart. It's almost like you shouldn't be all of us in the central, because we're so far apart. It's just the way, that's just the luck of the draw. That's just what we got. Because what we're doing out on 110th really doesn't affect what's happening at 40th East. But anyway, just a point.
Thank you.
Thank you. Is there any other people that want to weigh in?
I do.
Okay.
But I see that they're.
Yeah.
Okay.
And refresh my memory, Arden or council. Those boundaries that were created for those sub-basins, were those political boundaries? Were they hydrological boundaries? I think that's helpful to some of the questions that, been asked by the public as well as by the board. If you don't have the answer, it'd be good to follow up as well.
In general, they're hydrogeologic.
Has there been a review by the Watermaster engineer to confirm those post-mortem of the judgment?
What do you mean by review those?
They're accurate. Have we looked at the data? Do we see what flows are between those two boundaries? Are you seeing impediment, right? And typically subbasins are developed hydrologically by impediments that, can create not a even flow between the areas, right? And I am not a hydrological engineer, but becoming one through osmosis.
Well, that's neat. No, I think it was directed to the Watermaster engineer.
Yeah.
I was just clarifying the question.
Okay.
So there has not been a formal review of the sub-areas. One difference that we have observed and incorporated into our contours is that the boundary that sort of represents where we see a big shift in water levels, which does suggest that there's some sort of physical barrier between the central and the southeast sub-area, doesn't match exactly the southern portion of the sub-area boundaries. So this is shown in figure 2 that we attached, and I'll share my screen real quick again. In figure 2, attached to the memo, where we have the sort of orange line that we use as the contour boundary, and then we have this black line, which is the sub-area boundary. And in the south, we do see a difference. We see that the water levels, you know, in the southeast area sort of show similarities and extend, and the contours extend, showing similar water levels into the central antelope subarea. But there is that contrast between water levels within the central antelope subarea.
Madam Chair, I have a comment.
Sure.
Okay, so I just wanted to speak to kind of, first of all, I appreciate the report, but I do have some concern about moving forward with a proposal right now and what's, you know, the potential for the proposal. And that's really because I think, I do concur that we should watch, but I don't know that this is the right time to go into further analysis in this area. So that's my comment.
Can I just mention a word of clarification? These are called sub-areas in the judgment, not sub-basins. I think we need to remember that.
Thank you.
They're defined specifically in the judgment, and the indication is one basin.
Yeah.
With multiple sub-areas for management purposes.
And my intention was not to qualify those as separate basins at all, but understand, I think what we've heard from the engineer, that there are some hydrological impediments that happen between those sub areas that I'm calling out.
Okay. Are you finished, Arden, or?
Chair, I do need to step away. And Helika is online to step in for me.
Yes.
Well, if we're not done. I think it's closed session.
Yeah. So, okay, I can get us real quick to that. We are now on 19, which is board members' request for future agenda items. Okay, hearing none, we will go to closed session, conference with legal counsel, general counsel's report. And everybody's good since we had a 5-minute break? Okay, all right. We will go to, do you need a motion, please? A motion?
Second.
Okay, I have a motion and a second. Is there any public comment? Hearing no public comments, all those in favor signify by saying aye.
Aye.
Okay, thank you. And drive safe, don't rush.
You got us there, Madam Chair.
Recording stopped.